If you're stuck between a long, expensive trial and yet another failed mediation or fear of failed mediation, there's a third path you should consider: arbitration mediation, or Arb-Med. Here's a short summary of how it works, why it saves time and money, and when it's worth it. Quickly, the concept. We start with arbitration. Think private judge. Yes, we start with arbitration, with each side presenting evidence, exhibits, and testimony to the arbitrator. At the end of the hearing, the arbitrator writes a decision and then seals it. Next, we move to mediation a day or two later, with the same person who served as arbitrator now serving as your mediator. If you settle in mediation, the arbitrator's decision never sees the light of day. After all, it was sealed. If you don't settle in mediation or choose not to proceed to mediation, the arbitrator unseals the award and it becomes binding. Closure either way. Why people like Arb-Med? It helps them focus. With a written decision sitting in reserve, posturing evaporates. It compresses time. If mediation fails, you still finish the case without trial prep, trial days, and months of waiting for a ruling. It's less expensive than slogging through full litigation, and it's emotionally cleaner. Now see you in 6 months after a failed mediation doesn't happen. Common objections miss the mark. Power imbalances? Well, those exist everywhere. At least in Arb-Med, both sides see the merits, a merit-based reality check before negotiating. What if one side thinks he or she already won? Well, that side can choose not to mediate or engage in settlement negotiations anyway. The process still ends efficiently either way. Isn't this extra cost? Not when you weigh it against discovery battles, pretrial motions, continuances, and trial prep. Arb-Med front-loads the truth test and channels it into a final shot at self-determination. When does Arb-Med shine? Well, disputes with clear facts but high emotion, custody schedule, specific assets, alimony, cases where both parties want privacy and speed, situations where a fast, focused chance to settle would probably succeed if only both sides saw the likely outcome first. When not to use it? Where you truly need broad third-party discovery or court enforcement tools before anyone can evaluate the merits. Bottom line, Arb-Med blends certainty with control. If you settle, you chose it. If you don't, you still finish conclusively. If you want off the litigation treadmill without gambling your entire case on a single mediation session, consider Arb-Med.